All right, hello and welcome to Win Without Law School. This is our first class on case strategy creation. So I'm Arizona lawyer Julie Lebenz. Thank you so much for being here today. We are going to cover a really important part of a divorce case, which is creating a case strategy. A lot of self-represented parties don't realize how important this step is, and they just skip over it and start jumping into the paperwork, but without having a plan in place, and otherwise, a set of requested outcomes for each issue in your case, it can be really overwhelming and confusing about, where you are and where you want to get to. So as far as a divorce case goes, today we're going to talk about two potential issues that can come up in a divorce, which are property division and spousal maintenance. So let's jump in. Let me keyboard here. See, there we go. And hopefully the picture here isn't too much of a problem. I'll see what I can do there. Okay. Outline of today's lecture. So we're going to cover 5 different topics. First, I'm going to talk about why and how to create a case strategy. Part 2, we're going to go over some key property division laws in Arizona that come up in divorces that'll help you figure out your property division strategy. And then in part 3, I'm going to go over with you a technique that I use in every single divorce case I handle, which is creating what I call a property division spreadsheet. And so we'll go over that in detail. And then in parts 4 and 5, we're going to get into the spousal maintenance statute and help you analyze spousal maintenance in your case from both angles, either requesting it or being the spouse that is objecting to the other side's request. So we'll look at it from both sides. All right, let's jump into part 1, why and how to create a case strategy. A case strategy helps you get clear about your desired outcome. So if you go to a court hearing and the judge turns to you and says, well, what do you want to happen with the marital home? You have a response. If your case involves custody and the judge says, well, what do you want? What's your legal decision-making request? You would know what to say because you would have your request figured out. Same thing with spousal maintenance. So a case strategy helps you get clear about your desired outcome. What do you want the court to do about each contested issue in your case? By creating a case strategy, you will be able to tell the judge what your desired outcome is and why. And creating a case strategy helps you determine if you're adopting a reasonable position or not. When you're not in family law and dealing with these issues all the time, sometimes it's not clear what's reasonable and what's not in the eyes of the law. And first is to create your position. And then once you have that, you can run it by a lawyer, potentially the judge, depending on where you're at in the case. Of course, I wouldn't want to wait that long, but most importantly, you could consult with a lawyer and really figure out where you stand on your position. Now, for property division, your case strategy explains your request for how the court should divide all community assets and debts. So all marital property that you have at the time of your divorce, you need to have a request for how all of it should be divided. And then for spousal maintenance, if you are requesting spousal maintenance, your case strategy includes the amount of spousal maintenance you are requesting and for how long you are asking spousal maintenance to be paid to you. So you're going to need to show why you qualify, and then you're going to have to figure out how much am I asking for per month and how long, how many months should the spousal maintenance be paid. Now, if you are the opposing party and you are opposing your spouse's request for spousal maintenance, then your strategy consists of determining arguments for evidence to use to show your spouse does not qualify, as well as arguments against your spouse's requested amount and duration. So obviously, if you're opposing, you're going to be looking for evidence to support your opposition. Whereas if you're requesting it, then you're looking for evidence to support your request. And keep in mind that the court is going to want you to figure out how much spousal maintenance you're asking to be paid and for how long. Okay, let's jump into part 2. Let's talk about property division laws that are key to a divorce case in Arizona. So first, we're going to talk about the definitions of separate and community property. Then we're going to talk about the equitable division of community property, and we're going to touch upon a concept called waste. So Arizona is what is known as a community property state. And community property are all assets and debts acquired during a marriage, unless those assets or debts were acquired using separate property, inheritance, or a gift. So separate property are assets and debts acquired prior to marriage or acquired during marriage through inheritance or a gift that are kept separate property. So what community assets and debts did you and your spouse acquire during your marriage that you have at the time of your divorce? You're going to want to start making a comprehensive list of all marital assets that you have at the time of divorce. And we're going to go over more. We're going to go over that spreadsheet. So that's going to help you start creating your list. In Arizona, by law, the court has to divide all community property equitably. And the starting point for an equitable division is 50-50. In fact, the courts are obligated to do a 50-50 division unless there's proof, there's some evidence, there's some facts in that case to show that a non-50 division, a non-50-50 division is fair in that particular case. So there's one main case on this. And it's back from like the 70s or 80s, I think. It may even be earlier than that. But in that case, this couple met at a nursing home and they got married. And when they got married, the husband had owned a house and it was paid for, I believe. And he added the wife to the title, and then their marriage fell apart like a month later. And so presumptively under Arizona law, wife would have a 50% interest in the house because he added her to the title. So, they acquired this property together during their marriage. And so presumptively it'd be a 50-50 division, but the court concluded no, in these exact circumstances where she really didn't contribute to the house at all, it shouldn't be 50-50. Now, they didn't give 100% to husband. They did give her some interest, but it wasn't a 50% interest. So bottom line is you're going to be looking at a 50-50 division unless you have some compelling reason for a non-50-50 division. And you're going to need to explain and prove why the non-50-50 division is fair in your situation. Okay, if you have any questions about community property, let me know. There's also another important concept in Arizona called waste. So Arizona is a no-fault divorce state, and the court will not punish either party for any sort of immorality that they engaged in during the marriage. However, although it's a no-fault divorce state, the court will look at wrongdoing with money and will potentially seek to balance the scales if there's some proof that one party, what we call wasted community asset. So waste is defined as excessive or abnormal expenditures, destruction, concealment, or fraudulent disposition of community property. If you believe that your spouse has wasted marital property and you allege that in your petition and the matter goes to trial, then you would have the initial burden to show the money or property that was excessively or abnormally spent, destroyed, concealed, or fraudulently disposed of. And once you made that showing, then the burden would shift to the opposing spouse to prove the money or property was not wasted, but was used to benefit the community. So the main case law on this point is called the Gutierrez case. And in that case, the husband made a withdrawal from a 401k account, and then there was no accounting of the money thereafter. And so at trial, wife showed the statement showing the withdrawal, And that met wife's burden. And so then the burden shifted to husband, and he needed to prove that the money he withdrew from the 401k benefited the community, and he wasn't able to do that. So the court found the withdrawn money was waste and ordered husband to pay wife 50% of that amount. So I think it was around $40,000. Husband already owns a 50% interest in it. So 20 of that is already husband's. And then he was ordered to pay wife 20,000 to make up for her interest that he wasted. So I've had several cases where I've put forth an argument that excessive credit card spending amounted to waste, but I haven't been successful with that. The judges have been like, no, community credit card spending is not a big deal. I'm still pursuing that argument because I think it's valid, but I haven't had a lot of success with that. Okay, we've got a question. Arizona has a covenant marriage license. Are you going to touch base on the covenant marriage aspects to get a divorce? That is such a unique thing. Maybe you have a covenant marriage and there are separate statutes for that in Arizona. I've only had one case in my entire career that involved a covenant marriage. And if Paul, you have one, I could do like a separate training on that, but it is very rare. It's a religious-based marriage, and you only qualify to get divorced under certain circumstances. And that's really one of the cruxes of the covenant marriage statutes, is figuring out how to get to fit within those requirements to dissolve a covenant marriage. Everything after that is pretty similar, if not identical, to a regular divorce. Okay, so that's waste. Now let's talk about how to create a property division spreadsheet. Now, this is something that I use, and this isn't necessarily something you're going to find through like the court's documents or something like that. There's no order to create this. You're not required to exchange this particular document with the other side. The court does have one form called an inventory of assets and debts, which is similar to this, but I organize it a bit differently to include values and adding up numbers and things. And I'll show you all of that in a minute. So in step one of creating a property division spreadsheet, you're first going to create a list of all of your community assets and debts that you have at the time of your divorce. Step two is determine the current value of each community asset and debt. Now, this may take some legwork. Some stuff will be very easy to determine. What's the amount of your outstanding mortgage? Look at the statement. What's the balance of your bank account or credit card debt? Look at the statement. You can find that. But what's the value of the marital home? You can look on Zillow. There's different ways to get some values, but of course, that's going to be something that's changing as your case is unfolding and not as easy to determine. Same thing with valuing a car. Certain assets that don't have a balance related to them can be a little more difficult to value, but that doesn't mean that we still don't do it in the divorce. We just have to take some extra steps. And we'll talk about that a bit more with the spreadsheet. Once you have your list of assets and debts and you have your values, you're going to add up all of the values to get the total value of the community property. And then you're going to divide by 2. And that's roughly the 50-50 division. That's roughly the amount of money each spouse should leave the marriage with. From there, you can assign property to debt to each spouse, start figuring out what your property division proposal is. And then you can add the value of the assigned property and debts that you propose to be assigned to each spouse and see how close or far you are from a 50-50 division. So, okay. Now I'm going to share a different screen. So just hold on a second. Okay, the screen is loading. Here we go. All right, so this is a made up example of a property division spreadsheet. And so you can see here in this first column, this is your list of assets and debts. Now I put in some some property categories here to help you think of different types of property to include. And of course, not every marriage is going to have all of this type of property, but here are just some ideas. If you have real estate, if you and your spouse bought one or more pieces of real estate during your marriage and you didn't sign a disclaimer deed that's titled in both of your names, or if it's only in one name, there's no disclaimer deed signed, then I would list the marital home. If the marital home is subject to a mortgage, I'm also going to list the current value of the mortgage. With real estate, like we talked about, getting the value of the home can be a bit difficult, but you can do a general Zillow valuation, at least to get a starting point. You can also contact a real estate agent and see what they would list your property for, to see if, just to get some ideas of potential market value. Okay, just 1 second. I'm reading a question. Okay. So there's a question about if there's an agreement to turn over ownership to one spouse, and then if or when the property's sold, then at that point, the non-owning spouse would get their interest. And so the question is, if the house is sold, can anything be done if I was told it was sold, but that is not true, can anything be done if no date was put in writing when the house is to be sold? Possibly. You have to look back at your divorce document and see what the exact language was. But if it's a full open-ended, just if and when it's sold, you get your share, yeah, there likely is no obligation to sell right away, or if ever, which can be a problem. So I take a look at the real fine detail of the document and see if you can find anything that triggers the ex's requirement to sell. Okay. So you'll want to get a value for the marital home. If it's subject to a mortgage, could get the current value of the mortgage. It's really important to incorporate the debt associated to the house. You can't just list the asset value. You've also got to list the debt. We've got another question. Can you get help with value that will stand up in court? Yeah, proving your values is really important. And this is where, for each item on your list of your property division spreadsheet, ideally you have a document to support the value you're using. So for the marital home, printing out the Zillow valuation, getting a comparable market analysis from a real estate agent or two, or spending the money for an appraisal. Those are all ways to get valuations that the court will consider and potentially rely upon for the value of the home. Also, keep in mind that if your proposal is to sell the home, you really don't need to worry too much about putting a value in a property division spreadsheet. Instead, where this 500,000 is, I would just put sell with net proceeds to be equally divided, because the final price is going to be determined by market value and whatever the buyer pays. So if you're going to sell and that's your proposal, you don't need to spend too much time on getting the value. But if you want to buy out the other side, or you want your spouse to buy you out, then the value can be more important. Okay, bank accounts. Now, this is another thing where a lot of times for values, people will use the value as of the date of service of the petition for dissolution as the value to use for the bank accounts. And that's definitely an option. But, in reality, beyond the date of service, withdrawals and deposits, there's all sorts of transactions that continue to happen in the accounts. So it's really a case-by-case basis. Either you can decide on a date and divide the value of the account as of that date, or you can just say, look, I'm going to take this account, you take that, and we've paid a bunch of expenses out of those accounts in the meantime. I think it's fair. It's really just going to have to be something you analyze And I think bank accounts are most critical to divide if there's some account that has a big lump sum in it or something like that. But if it's an account that's used to pay joint expenses, the value is going to be changing constantly. Okay, vehicles. Getting a value for vehicles, there's Kelley Blue Book, there's Edmunds. You can go to a dealer potentially and get a written quote for what they would purchase your car for. So there are some ways to get values, but they're often disputed between the parties. Like they'll run a different Kelley Blue Book, because they used a trade-in value instead of a private sale, or they had a different mileage listed, or they have different, quality of the condition of the car. So there can be a dispute over values, but I wouldn't get too caught up in that at this stage. Right now, the most important thing is to come up with a value to use. And I'd look at Kelley Blue Book or Edmunds. Make sure you account for the current value of any car loans, so you can get that from your statement. Also be looking at whose name is on the car loan. Is it in just one spouse, or is it in both spouses' names? Because if it's in both names, then you may need to take some steps to get a car loan rewritten so that you're not both on the car loan. So it's a little bit of investigative work to do. Retirement accounts. Now, whether or not you can put a value in here is going to depend on the type of account at issue. If you have what's called a defined contribution plan, like a 401k, where money is put in and there's, you get a statement that tells you the value of the account, then you could put that type of account in here, an IRA, a 401k, that's going to work that way. But if instead the retirement account is a pension, like the Arizona State Retirement System, for example, that's what's called a defined benefit plan, where by virtue of working for Arizona, you get an interest in the retirement system. You get like credits into the system, which entitle you to benefits upon retirement. And that's going to be divided differently. And you're not going to be able to just put a number in here because it's defined benefit. It's not a defined contribution. So you'll need to investigate if there's retirement accounts at issue, what are they? Are they defined contribution, or are they defined benefit? And is there a reason to divide them other than 50-50? Because if your request is just to divide the retirement accounts 50-50, then that can just be your request, and you don't need to spend too much time figuring out values. Let's look at another type of account, which is an investment account, like a stock account, also known as a brokerage account. Robinhood, I put here, that's one type. What's some other ones? Fidelity, Vanguard. Those are some coming to mind. There's another one I'm trying to think of that's slipping my mind. But the bottom line is this is a brokerage account. So this is where someone's investing into stocks and things like that. So you can propose that that type of account be equally divided. Let's say the stock account is in your spouse's name and you don't have access to the statements. You have no idea what the balance is. Well, I would list it, and then I would make a note, okay, I need to request a current statement from the brokerage account from my spouse so I can see what the current balance is. And that's true for any of these numbers. If you're doing your spreadsheet and you find that there's certain values you don't know, then that's where you're making a note. Okay, I need to find this value and figure out what steps to take to get your hands on that information. Okay, another potential type of property to list on your property division spreadsheet would be credit card debts. So listing each credit card that each spouse has, that they opened during the marriage, that they have at the time of divorce, and then getting a current balance. So with this example that I'm using, once we listed our assets and debts and we have our proposed values, I then add up the value column. And the total value comes to this 308,000, almost 309. I divide that by 2, and each spouse should leave the marriage with roughly this 154,000 amount. So in this proposal, we're contemplating husband buying wife out of the marital home. So we have the house and the mortgage going to husband. We have the bank accounts going to wife. Husband gets his vehicle and car loan. Wife gets her vehicle and car loan. We're going to suggest a 50-50 division of the retirement accounts, a 50-50 division of this Robinhood account, and then husband gets his credit cards, wife gets hers. Now, when we add these columns up, husband has almost 300,000 in value and wife has only 14,000, yet both are supposed to leave the marriage with around 154,000. So you have a couple of options at this point. Either one, you argue for a non-50-50 division of the property, but like we talked about earlier, you're going to have some really strong justification for that. If there is no justification, you don't want to make that argument. Then number two, you could play around with your proposed division so that these numbers get closer, propose the house be sold, change around some of these numbers. Alternatively, there can be what's called an equalizer payment. So what this is we take the amount that husband is receiving under this proposal, and we subtract it from what he should get if it's a 50-50 division, and it's this $140,000 difference. Same thing here, we take this amount, subtract it from the 50% amount, and we get this 140,000. So under this proposal, husband could pay wife 140,000, let's say, and he could refinance the house and get that money or something. And then that equalizes it out and it's a fair division. Now, one thing that I didn't list on here is personal property. Consider that, all of the things around the house that don't have a title to them, your couch, your kitchen appliance, not appliances, but all your kitchen stuff, the beds, the wall decoration, everything in the house, that's all called personal property. And that needs to be divided up as well. So you're going to have a couple of ways to approach that. Number one, you can get together with your spouse and work it out. Okay, just get together one day, I'll take that, you take that, and get to a point where you each believe it's fair. Number two, you can make a list of all the property, do research on Craigslist and eBay and Facebook Marketplace and find comparable values for the used property. Remember, you're going to use the current value, not what you purchased it for, because it's now used personal property. And then look to, if you're going to keep the majority of the stuff, then pay your spouse their 50% interest or vice versa. It really just depends on how detailed you want to get and probably, how valuable or how much personal property you have. But a lot of people take a pretty practical approach to this and just figure out a division and don't get too caught up in the details. But in some cases it's merited. So you'll just have to decide what's best for you. Okay, we've got a question. Are there spreadsheet examples or templates that can be downloaded as a starting point? Yeah, we'll throw those into the members area, definitely. Any Excel spreadsheet can be made to look like this, but I'll definitely throw this spreadsheet into the members area so you can put in your own numbers and play around with it. Okay, so this is the spreadsheet. Again, there's other types of property you can list on here, and you want to be comprehensive. You want to include everything. Life insurance policies are another thing. If they have a cash value, you still need to assign the policy whether it has a cash value or not. But if it has a cash value, that makes it more important to include on your asset division spreadsheet. I'm just trying to think if there's any other property we want to talk about. Cryptocurrency, any sort of collector's items, also precious metals, gold and silver, anything like that. Everything should be included. If you have cash stashed at the house, some people do that. They get a safe and as a married couple, you stash cash at the house. That should be divided too. A business, let's say you started a business together. That can be more complicated because what is the value? And so businesses are more difficult. First of all, you need to decide what's going to happen with the business. Is it going to continue to operate? And if so, are you going to operate it together? or is one side or the other going to operate it? And if it's going to go to one spouse, then that spouse is going to need to buy out the other's interest, which likely requires a business valuation to be done, which costs $5,000 to $10,000, depending on the business. So businesses are more complicated. I definitely recommend getting legal advice if you've got a business to be divided in your divorce. Okay, I'm going to stop this share and go back to the slideshow. Okay, so we were at okay, so this is where I had gone to the property division spreadsheet. So now we're going to transition out of property. And we're going to talk about spousal maintenance. So if you have any final property questions, feel free to throw those in the chat. Otherwise, let's talk about spousal maintenance. Now, spousal maintenance is really complicated. The statute's complicated. We've got guidelines I'll talk about in a minute that have been mandated but haven't even been released yet. And it can often lead to a trial. Spousal maintenance claims can often be litigated, and they can potentially be modified, which can create a lot of uncertainty going into the future. So spousal maintenance is complicated. And if you are seeking spousal maintenance and you can get it in place, that can be really favorable to you. On the flip side, if you don't want to pay spousal maintenance, or maybe your claim isn't that strong, this can be a really valuable issue to negotiate a resolution of in your case. Because if you can avoid spousal maintenance and maybe settle the spousal maintenance claim with a different division of your property, your community property, that can be really favorable. And it comes back to a couple of concepts. Number one, how much time, energy, and money are you going to spend fighting a spousal maintenance claim? Is it going to push your case to trial? How much is that going to cost, and what is that going to look like? And of course, what is the judge going to do? You have no idea. And then also, if spousal maintenance is awarded by a judge following a trial, the judge is going to make it modifiable. And so that means you could be looking at a spousal maintenance order that's due to expire in a year or something, and your spouse could move to your ex-spouse could move to modify it, and then it might get extended. So you just don't have a lot of options when you have this modifiability. I shouldn't say options. You don't have a lot of certainty because this potential looming modification is over your head. So when we talk about spousal maintenance, we've got two parts of the statute. And the first part of the statute is subsection A. And there's 5 parts to it. We're going to go over that in the next slide. And it lays out how to qualify for spousal maintenance. So whichever spouse is seeking spousal maintenance, they're first going to need to show how they qualify for the award. If they prove they qualify, then the court's going to get into this subsection B analysis, which is a series of 13 factors the court looks at to determine the amount to be paid per month and the duration for how long is that monthly amount paid. Now, just this past year in 2022, the state legislature revised the spousal maintenance statute and said that the court has to follow guidelines in determining the amount of maintenance to award. But those guidelines haven't yet been created. We're anticipating they'll be released soon, but we don't have them yet. So it's a little confusing, and we're likely going to get those guidelines soon, which will, I'll need to do an update to this because that could result in some changes. So I'll keep you updated on the guidelines. For now, 25-319A and B are where you're going to find all your resources as far as what the law is for spousal maintenance. So let's look at this subsection A, which talks about how to qualify for spousal maintenance. So here's part A of the statute, and it talks about how in a divorce, the court can grant a maintenance order for either spouse for any of the following reasons if it finds that the spouse seeking maintenance. Okay, so here's the 5 ways to qualify. Number 1, you lack sufficient property, including property apportioned to you in the divorce, to provide for your reasonable needs. Now, this kind of looks straightforward, but kind of isn't, because what is sufficient property? What are reasonable needs? Those are very broad terms. And in practice, what the court generally does is take this particular document called the Affidavit of Financial Information. It's a document that both spouses are required to fill out during the course of the divorce, and it details your income and expenses. And so often, if one spouse is alleging a claim to spousal maintenance under A1, that's what happens is they take their AFI and they say, look, here's my income, here's my expenses, there's a shortfall. So I lack sufficient property to provide for my reasonable needs. So that's usually how that is put forth. You get that AFI and then you use that to support this reasonable needs claim. Another way to qualify for spousal maintenance is to prove that you lack earning ability in the labor market that is adequate to be self-sufficient. So for example, you've been a stay-at-home mom for 20 years, and now you're being asked to, start working and make an income, but you only qualify for minimum wage jobs. And the minimum wage job isn't enough for you to be self-sufficient, in particular at the lifestyle you enjoyed while you were married for those 20 years. So that's really what that's aimed at, is looking at what are you capable of making and can you be self-sufficient? The court isn't always going to give you an inflated lifestyle to compare your earning ability to. If you're at minimum wage, the court will expect you to live a more modest lifestyle. However, if you came from $1 million marriage, the court's going to consider that. Of course, remember, the court's going to consider what you receive in the divorce in determining spousal maintenance. So if you're coming from $1 million marriage and you're getting $500,000, and then you need to go get a minimum wage job to help supplement your income, the court may find, look, you don't qualify because you got enough property out of the divorce. Third way to qualify, you're the parent of a child whose age or condition is such that the parent should not be required to seek employment outside the home. So a special needs child, an infant child, those could be some examples. And of course, if we're just looking at an infant child, then the court may say, oh, well, what are your daycare options? What does that cost? And also looking at a time frame here, how long do you need to stay with this infant before you can go back to work? So those would all be considerations in limiting a spousal maintenance claim under number 3. And then with a special needs child, there's going to be a lot of questions about what is the degree of special needs and why is the parent required, why should the parent not be required to seek employment outside the home? And that could likely include a cost benefit analysis. Look, bringing in help to care for the special needs child while I'm at work exceeds what I would make at work. And so it doesn't make sense for me to go to work. It makes sense for me to stay at home with the child. Those could be compelling arguments. Number 4, if you made a significant financial or other contribution to the education, training, vocational skills, career, or earning ability of the other spouse, or you significantly reduce your income or career opportunities for the benefit of your spouse, you could qualify for spousal maintenance. So if you got married and then you put your spouse through college and grad school, you worked side jobs and did all this stuff, and you gave up on college so that you could support your spouse, and then they became this successful lawyer or doctor or educator or whatever, that would be making a significant financial or other contribution. And in that same example, you didn't go to college to support that. And that's an example of reducing your income or career opportunities for that spouse's benefit. This can come up to being a stay-at-home parent. Look, I stayed at home and went out of the job market to care for our kids. And that significantly reduced my income and career opportunities and benefited the spouse because they got to continue their career. So these are some considerations the court will look at. And then finally, number 5, if you had a marriage of long duration, that's generally considered to be 10 years or longer. and if you're of an age that may preclude the possibility of gaining employment adequate to be self-sufficient. So 10-year or longer marriage, and you're of an age. So, that to me, that like retirement age, somewhere around there, you're already retired, or you're just about to retire, or, you're at this age where that may preclude the possibility of gaining employment adequate to be self-sufficient. If you're in your 70s and you're getting divorced, you've been married for over 10 years, and you're asking for spousal maintenance, that makes sense, rather than saying, oh, you need to go get a job at 70 years old. I mean, you're likely of an age that may preclude the possibility of gaining employment. Okay, so those are the ways to qualify. If you are wanting to seek a spousal maintenance award, then in your petition for dissolution, you need to indicate I'm requesting spousal maintenance, and you need to indicate under 1 through 5 what your claim is based on. And keep in mind, it can be more than one. You could lack sufficient property, and you could lack earning ability. You could lack sufficient property, and you could be a parent of a child with special needs. I could keep going, but I think you get the point that you're not limited to claiming just one. And in fact, if you're making a spousal maintenance claim, you likely want to make more than one, make your claim under more than just one of these 1 through 5 if you have valid grounds, because that's a strategy we like to use as a lawyer. Look, I'm not just going to hang my hat on one particular way to qualify. If I can see I have 3 ways to qualify, then I'm going to allege all of those to make my claim even stronger. Okay, so first, the burden is on the party requesting spousal maintenance. They need to show that they qualify under 1 through 5. If they qualify, the next thing is to determine how much is going to be paid per month and for how long, for how many months, or for how many years. For this, the court looks at subsection B. And this part of the statute was changed this past year to acknowledge the guidelines, but also notice that this language is in here that the court is only supposed to award spousal maintenance for a period of time and in an amount necessary to enable the receiving spouse to become self-sufficient. So there's a very keen focus on using the maintenance award to achieve self-sufficiency. What this means is that indefinite awards of spousal maintenance are now very frowned upon under Arizona law. And, this just changed last year, so we'll see how it happens in practice. But I would imagine getting an indefinite award is going to be very difficult with this new language. Okay, so let's look at these 13 factors. And this is confusing, right? Like 13 factors, what do I do with these? This is going to come up in crafting your case, either your request for or your request against spousal maintenance, throughout the case and at trial. So this is part of creating your strategy. If you say you qualify for spousal maintenance, how do you qualify under 1 through 5? And then we're going to get into this B, and we're going to look at the amount and duration, and we're going to look at these factors and how to use these factors to justify the amount and duration that you're requesting. Okay, number 1, the court is going to look at the standard of living established during your marriage. A lot of people have a hard time verbalizing what that means. And you really look at your lifestyle. Did you go on vacations? Did you have excess money to spend? Were you always short on money? Did you stay at home? Did you never eat out? Those types of things. Did you buy new clothes? Did you go to thrift stores? Really looking at the standard of living that you had during your marriage. How did you spend money? The duration of your marriage, for how many years were you married? And then first, we're going to look at the age, employment history, earning ability, and physical and emotional condition of the spouse seeking maintenance. And then look at the ability of the spouse from whom maintenance is sought to meet that spouse's needs while meeting those of the spouse seeking maintenance. So the court is entering into this balancing test of looking at each spouse and what are their circumstances. So for the spouse requesting maintenance, How old are they? What's their employment history? What's their earning ability? What's their physical and emotional condition? And then the spouse who's being asked to pay, well, if they pay $500 a month in spousal maintenance, for example, then how does that impact their finances? Will they be able to meet their own reasonable needs if they're paying that amount? Number 5, the court looks at the comparative financial resources of the spouses, including their comparative earning abilities in the labor market. So can wife earn 100,000 while husband can earn 65,000? So those are looking at like comparative earning abilities, and then comparative financial resources. Did wife recently inherit $200,000? That would be a financial resource to be considered, even though inheritance is separate property. That can still be considered in this financial resources analysis. Comparative financial resources. So, is there some other money or asset that the spouse could tap into aside from just their earnings? Number 6, the contribution of the spouse seeking maintenance to the earning ability of the other spouse. So if you were the stay-at-home wife who supported your husband's medical career, and now he has this huge earning ability and you don't, that's something that the court's going to compare and look at. And how did you contribute to your spouse's earning ability? Number 7, the extent to which the spouse seeking maintenance has reduced that spouse's income or career opportunities for the benefit of the other spouse. Number 8, the ability of both parties after divorce to contribute to the future educational costs of their mutual children. Number 9, the financial resources of the party seeking maintenance, including marital property apportioned to that spouse, and that spouse's ability to meet that spouse's own needs independently. So this is where the court looks at what you're getting in the divorce and throws that into the spousal maintenance analysis. Number 10, the time necessary to acquire sufficient education or training to enable the party seeking maintenance to find appropriate employment, and whether such education or training is readily available. So this goes to this idea that the maintenance order shouldn't be indefinite. It should be based on getting the spouse awarded maintenance to a place of independence and, being able to provide for their own needs. So if it's a matter of, oh, look, I didn't get my nursing degree while we were married because I was taking care of the kids, but now that we're getting divorced, I want to go get my nursing degree and it's going to take me 2 years and this is what it's going to cost, So the court will look at that and be like, okay, spousal maintenance for 2 years while you're getting your nursing degree, and then it's going to end upon your graduation or something like that. Number 11, excessive or abnormal expenditures, destruction, concealment, or fraudulent disposition of community, joint tenancy, and other property held in common. So this is the waste definition that we talked about earlier. The court will consider waste in a spousal maintenance analysis. So if one spouse is like, oh, I can't pay spousal maintenance because all that money is gone, the court's going to be like, yeah, well, you wasted it. And so we're still going to make you pay because that was your fault. So that's something that the court can consider. Okay, we have a question here. What about a boyfriend or girlfriend input into the finances of one over the other spouse? I'll need more information on that, Paul. See if you can clarify that question a bit. I think what you're asking, and let me know if this is true, is in this spousal maintenance analysis, does the court look at a girlfriend or boyfriend's income or finances? And the answer is, yeah, that could be deemed some of the financial resources that one party has. Child support's different. Child support does not consider a boyfriend, girlfriend, or a new spouse's income. It only looks at the parent's income for the child at issue. But in spousal maintenance, yeah, there could be an argument that, look, you have additional financial resources through your new girlfriend, boyfriend, husband, things like that. If it's like a short-term girlfriend or boyfriend, the court may not rely on that as much versus, oh, we're engaged to be married or we got married or something like that. Of course, that would be post-divorce because you couldn't get married while your divorce is pending. But yes, the court can look at all financial resources. Number 12, the cost for the spouse who is seeking maintenance to obtain health insurance and the reduction in the cost of health insurance for the spouse from whom maintenance is sought. If the spouse from whom maintenance is sought is able to convert family health insurance to employee health insurance after the marriage is dissolved. So essentially the court's just looking at, okay, if you had a joint health insurance policy and now you are going to have separate policies, how is that impacting each spouse? What's that cost? What's the deduction? And that can play a role in a spousal maintenance determination. And then finally, and this isn't going to apply in many cases because there would have to be a criminal conviction. But number 13 is all actual damages and judgments from conduct that resulted in criminal conviction of either spouse in which the other spouse or a child was the victim. So some sort of domestic violence or child abuse that resulted in a criminal conviction. So not just a charge, but an actual conviction, and then any actual damages or judgments from that conduct that can be considered in a spousal maintenance analysis. Okay, so we've got subsection A, parts 1 through 5 to show you qualify, or if you're arguing against your spouse qualifying, you'd show how they don't qualify under 1 through 5. And then if the qualification's been shown, then we're looking at B. I'd go through these 13 factors and first identify which ones apply in your case. And, when we look at this page, number 8, if you don't have mutual children that are going to have future educational costs, then that doesn't apply. If you weren't under the same health insurance, or there's really no changes to your health insurance coverage because each of you get coverage through your separate employers, that one's not going to apply. Number 13. So look through here and then narrow it down to the ones that apply, and then start answering, giving facts about your case, and see how you would answer each one and start building evidence around those. If spousal maintenance is awarded, do you want it to be modifiable or not? If you reach an agreement with your spouse regarding the amount and duration of a spousal maintenance award, then you and your spouse will also need to agree as to whether the spousal maintenance award will be modifiable or not. Okay. If you go to trial and the court awards one spouse spousal maintenance, then the award of spousal maintenance will be modifiable. If the parties agree that a spousal maintenance award is non-modifiable, then neither party may petition the court to modify the spousal maintenance award at any time. Whereas if it's modifiable, either side could go back and seek to change it. So the person paying could seek to reduce it at any time if they had a change in circumstances, and the person receiving it could ask to extend it or increase it if they had a change in circumstances. So the modifiability is a big deal. All right, we've come to nearly the end here. Let's do a quick summary. For property division, Arizona is a community property state. All assets and debts acquired during marriage are community property unless acquired with separate property or by inheritance or gift. All community property shall be equitably divided between the spouses, which means 50-50, unless cause is shown to divide property other than 50-50. We talked about waste. Do you have any grounds to make a waste claim? Create a property division spreadsheet to help you identify all community property subject to division in your divorce, the current values of each item, and to figure out your proposed division and determine if it's fair. Spousal maintenance. Review 25-319A1 through 5 to determine if you or your spouse qualify to make a spousal maintenance claim. If it appears you qualify for spousal maintenance, then analyze subsection B 1 through 13 to help you determine the amount and duration of spousal maintenance to request. If it appears your spouse qualifies for spousal maintenance, then analyze subsection B 1 through 13 to start creating potential arguments against your spouse's requested amount. and duration of spousal maintenance. Do you want the spousal maintenance award to be modifiable or not? One final point on spousal maintenance, in particular, in trying to figure out how much to request, really look at the shortfall between your income and expenses. That's going to be a great starting point. And the court's going to look at that too. So if you're really struggling with how much do you need, I'd get really clear with your budget and start figuring out what the shortfall amount is.